So what I hope to convey on this video podcast is uh, a summary or a look at some of the major court cases that relate to the California legislative process. As you might imagine, there are quite a number of California appellate court decisions relating to and explaining the legislative process used by the California legislature. A lot of these cases deal with a number of different and very distinct issues, but these are the ones that I think that capital insiders should probably be aware of. The first is Kaufman and Broad Communities versus Performance Plastering, a California Court of Appeal decision in 2005. And it essentially clarifies that a determination of the existence of an ambiguity in a statute occurs not at the time of a motion for judicial notice, but instead by a panel of judges hearing an appeal. Even more importantly, it lists the cognizable and non-cognizable aids of legislative history that can be utilized by the courts to interpret statutes enacted by the legislature. And it also sets forth the process of taking judicial notice of different types of cognizable legislative history, including an enrolled bill report from the governor's files. And so it basically sets forth the form to be utilized and how a motion for judicial notice must be made in this state. Another well-known one is Association for Retarded Citizens versus the Department of Developmental Services, a 1985 Cal Supreme Court case, which was an effort by associations and individuals against DDS, alleging that certain spending directives issued by the DDS director were void. And the Court of Appeal said that administrative action that's not authorized by or is inconsistent with acts of the legislature are void. Although they will give certain weight to the construction of legislative acts, ultimately, if they're inconsistent with other acts of the legislature, they are in fact void. A well-known one is People's Advocate versus the Superior Court of Sacramento, with the California legislature being the real party in interest. This was decided by a court of appeal in 1986, and it challenged an initiative, a statutory initiative that set forth in the government code internal rules of the legislature, including selection of officers, selecting committees and the powers of the committees in the two houses of the legislature, limiting the contents of budget legislation, and things like that. And the Court of Appeal found that a number of provisions of this initiative measure violated the state constitution. It did allow some other provisions, such as those relating to secrecy in legislative proceedings, found that those were severable. But otherwise, they said that the authority to enact statutes which appropriate money, including the legislature, is set forth in the Constitution. And so the provisions of this statutory initiative were inconsistent with the state constitution and therefore void. We go way back to a Cal Supreme Court decision from 1905 in French versus Senate, where the Cal Supreme Court said that a house of the California legislature has the power to adopt any procedure and to change it at any time and without notice, and that it cannot tie its own hands by establishing rules. which couldn't be changed or disregarded in the future. It said the Cal Supreme Court said, its action in any given case is the only criterion by which to determine the rule of proceedings adopted for that case. There's a famous saying around the legislature that the legislature can't bind future legislatures. That actually comes from the California Supreme Court in the case of In Re Colli, a 1952 decision, where the Cal Supreme Court said that neither house of the legislature may bind its own hands or those of future legislatures by adopting rules that are not capable of change. The court went on to say it's the general rule that one legislative body cannot limit or restrict its own power or that of subsequent legislatures, and that the act of one legislature does not bind its successors. A big case related to so-called spot bills was decided by the Court of Appeal in Howard Jarvis Taxpayers Association versus Bowen, a decision rendered in 2013. They wanted to address a narrow but potentially recurring and important question, whether the California Constitution, as amended by the voters in 2010 by Prop 25, allows the legislature to identify blank bills with an assigned number but no substance in them, these so-called spot bills, in the budget bill, and pass the budget and add content to these placeholder bills and approve them later by majority vote. The court concluded that spot bills which remain empty of content at the time the budget is passed are not bills that can be identified within the meaning of Article 4, Section 12E2 of the California Constitution. So the court basically said that the legislature cannot add content to an empty spot bill as a means of otherwise avoiding the 2/3 vote requirement for urgency statutes. The next case to highlight is Marine Forest Society versus the California Coastal Commission. This was issued by the California Supreme Court in 2005 and deals with the separation of powers doctrine in Article 3, Section 3 of the California Constitution. In this decision, the California Supreme Court upheld the constitutionality of the California Coastal Commission. It basically found that there was nothing to support a finding that the structure of this independent commission violated the separation of powers doctrine. The court evaluated the structure and looked at the statutes comprising it, and again, basically found that the structure of the commission was permissible and valid under the state separation of powers doctrine. The next case deals with determining who has jurisdiction over deciding the qualifications of a legislator. And this was a famous case in 1986 by a California Court of Appeal. It's the case of California War Veterans for Justice versus Tom Hayden, then a member of the state assembly. And the appellate court said that the jurisdiction of a legislator's qualifications belongs exclusively to the assembly. And they said that under the California Constitution, as under the federal Constitution, and in fact, the law of most states, it's the legislature who has sole jurisdiction to determine the qualifications of its members, as well as having the sole right to expel a member from membership. And this is set forth in Article 4, Section 5 of our state constitution. And so for over 100 years, the appellate court said, the California Supreme Court has consistently held that under our state constitution, the courts actually have no jurisdiction to inquire into the qualifications of the members of the legislature, that power is held solely by the legislative branch of government. The last case I think that's noteworthy was by the California Supreme Court in 2014. It's Howard Jarvis Taxpayers versus Padilla. And this was an effort to pull Proposition 49 from the November 2014 ballot that the legislature had placed. Prop 49 was proposed as an advisory vote on whether Congress should propose an amendment to the US Constitution to overturn a controversial campaign finance decision by the United States Supreme Court called Citizens United. The California Supreme Court concluded in the Padilla case that the legislature has the power to investigate the need for legislation. And so at least they said for a question pertaining to an amendment or a proposed amendment to the California Constitution, the legislature may exercise that power by placing an advisory measure on the ballot and receiving feedback by the electorate. So this is a decision that was basically limited to advisory votes on amendments to the federal Constitution. There is something of note I found in footnote 6 of this decision. It states, because we conclude the investigative power permits advisory questions in connection with potential federal constitutional amendments, we express no opinion about other potential sources of authority for advisory questions. Obviously, there are hundreds of cases interpreting different aspects of the California legislative process, but the cases we've chatted about today are some of the major ones that are most often cited.